Thank you very much. It's a great honor to be here. It is indeed my first time at this symposium. I recognize a lot of you from ALAI, and I think that ALAI is responsible for my being here, since at the previous ALAI in Denmark, Yuka asked if I would contribute to this symposium, and when Yuka asks, there's only one answer, so here I am. I'd like to thank Yuka and all the organizers of this symposium for the opportunity to think about extended collective licenses in international treaty perspective. Now, first of all, the international treaty issues arise only if there is an element of extraneity, of internationality, because the Berne Convention by its own terms does not apply to domestic works in the country of origin, which means that the issues concerning ECLs remain domestic issues unless either the local collecting society grants local licenses in foreign works, or the local collective society grants extraterritorial licenses in local works. And in that case, in those two cases, the Berne issues arise most specifically whether or not the ECL in the version that allows non-members to opt out of the license is a formality inconsistent with the Berne Convention, and whether, as Astrid Lund discussed this morning, whether the ECL violates the three-step test. There is, in addition, with respect to extraterritorial licensing, there are some private international law questions that arise, because it doesn't do any good to grant rights for a foreign territory if the foreign territory doesn't recognize the extended effect of the ECL. There are plenty of reciprocal agreements with respect to collecting societies whose members have affirmatively joined. There are, I understand, in the Nordic countries, reciprocal agreements that include ECLs, but on a worldwide scale, there is not yet a network of mutual agreement concerning the extended effect of ECLs. And that raises kind of an interesting question about whether the extended effect would be valid in the territories for which the rights are granted. That would, of course, depend on whether there is enabling legislation in the foreign territory, which at the moment is not necessarily the case. I think that the applicable law would indeed be the law for each territory for which rights are licensed. I thought about whether Rome I might supply a choice of law rule, but I really don't see it. I mean, one could argue that it's the habitual residence of the debtor of the characteristic performance, which might be the author, but all of that assumes that there is a contract, and the whole point of an ECL is that it covers those who have not actually contracted with the collecting society. So I think that the applicable law would have to be the law of each territory for which rights are granted, which means that there's probably a fair amount of work to be done around the world before we can have truly multi-territorial transnational ECLs. With respect to the Berne and TRIPS issues, it's a given that under the rule of national treatment, foreign authors that might be covered by a local ECL have to be treated the same as local authors. I don't think that that is a problem in fact, but I just mention it. What may be more of a question and more contentious is whether, with respect to those ECLs that give non-member authors the opportunity to opt out of the extended effect of the license, is that a formality in the sense of the Berne Convention? You have on the slide the text of the relevant portion of Article 5.2 of the Berne Convention, and so the question becomes whether or not an ECL subjects the exercise of copyright to a formality, the formality being the opting out of the extended effect. And there are, not surprisingly, different views. One view, which I believe has been expressed by Johan Aksam and Lucy Guibault in their masterful study of the international effects of ECLs, which I highly recommend, take the position that an opt-out is a formality because it conditions the exercise of the right, the author's ability to exercise the right on compliance with the declaratory obligation of opting out. A different point of view, which I have advanced, is that not every declaratory obligation is a formality in the sense of the Berne Convention. That my understanding of Article 5.2 is that it goes to the existence of protection, the scope of protection, and enforceability, but not ownership. And that what we're talking about with the extended effect of an ECL arguably is a condition on who exercises, not how the right may be exercised. As to how the right is exercised, that's clearly in the core of 5.2. With respect to who exercises, I think that that is more ambiguous because there certainly are a variety of formal conditions that we would not consider to be formalities in the sense of the Berne Convention, of which perhaps the most universal is the requirement that any transfer of exclusive rights be in writing and signed by the author. But we don't think that that is a formality in the Berne sense, for good reason, because the formalities in the Berne sense, especially when one goes back to why the Berne Convention has, since its inception, limited and ultimately prohibited formalities, were that these were conditions that hindered the author's exercise of her rights, whereas the requirement of a signed writing is author protective. So an author protective formal obligation is not a formality in the sense of the Berne Convention. And I have suggested that more broadly, conditions on the transfer of ownership should be considered not a formality in the Berne sense, but I'm looking forward to Johan's repost on that issue. Now, I know Johan will talk a lot about the recent Soulier decision from the Court of Justice of the European Union, so I will not go into so much detail about it. I will suggest, however, that it is consistent with my view of what's a formality. This is the decision in which the ECJ invalidated a French law on unavailable books that would have enabled books published in France before 2000 to be digitized subject to an opt-out by the author or publisher. And in addition, in a rather bizarre portion of this law, required for the author to exercise her opt-out and her right to retain the digitization rights in the work, it was necessary to prove that the print publisher didn't have any rights, didn't have not only the digital rights, but not even with respect to future uses the print rights, which is very odd. In a number of respects, the French law kind of effected an expropriation from authors to publishers, but I'll leave the details to Johan. The Court of Justice invalidated the French law as being contrary to EU norms as well as Berne Convention norms, but for different reasons. With respect to EU laws, EU norms, the problem was the inadequacy of the information concerning the opt-out. So it wasn't an opt-out per se, but it was the implementation of the opt-out. The court did not invoke Berne Article 5.2 until the second issue, which was this bizarre provision about the rights or non-rights of the print publishers. And I gave you the relevant paragraph 51, in which the court characterized as a formality the requirement of proving that other persons are not otherwise holders of other rights in that work, such as concerning its exploitation in printed format. So I would, under my analysis of what's a formality and what's not a formality, the reason that this strange obligation is a formality becomes clear if you compare the normal requirements of proof when an author or successor in title brings a copyright action. And the first thing that you have to show is that you're the owner of the right that you are asserting. That's not a formality. That's part of proving your claim. But requiring that authors prove that somebody else is not the owner of some other right is a burden on the exercise of the right, because it doesn't go to who owns the rights that the author is asserting. It goes to something else, and it's the something else that is a burden on the exercise of the author's rights that makes it a formality. I'd be very curious to hear what Johan has to say about the Soulier case and that particular interpretation of the Soulier case. Now, finally, and I can do this in much shorter order because Austri did the work for me this morning, if the ECL is one that does not allow an opt-out, we no longer have a problem about formalities, but we may have another problem, which is whether or not it is effectively an exception or limitation on the exercise of rights. Right? Because now we're not talking about a consensual or a presumed consent to the exercise. We're talking about taking away the author's consent to the exercise of those rights. I think that does put it in the camp of being an exception or a limitation. Does that mean that it violates Berne Article 9.2, TRIPS Article 13, et cetera? Not necessarily. There are the three steps, which are fairly flexible. As Austri indicated this morning, it's really the first one that might be problematic, so long as the ECL is confined to relatively narrow instances like educational photocopying. I think that it fits the certain special cases fairly easily. However, the more the ECL becomes generalized, the more tension there is with the threshold requirement that the exception or limitation be narrowed to certain special cases. The discussion this morning, however, gave me an idea which may not hold water, since it's a recently sparked idea, but in the discussion of representativeness, which of course is a very big issue, I was wondering if representativeness might also be taken into account in certain special cases. so that the more the ECL is representative, the better it might fit within certain special cases. The lower the necessary quotient of members who have agreed to be represented, the greater the problem of the generalization of the ECL. So if people would like to think that one through as representativeness as an element of certain special cases, I think that might warrant some further discussion. As for the remaining two considerations, does not conflict with a normal exploitation of the work. I think that the reason for ECLs in many instances is the problem of market failure, which is kind of a classic reason for not conflicting with a normal exploitation of the work. Johan and Lucy Guibault have posed a number of other instances in which the second condition would be met even outside of market failure. I'll leave that to them. Finally, does not unreasonably prejudice. It's generally viewed that providing remuneration might satisfy the third criterion as opposed to an outright uncompensated exception. ECLs are set up to provide for remuneration, including to the non-members to whom the license extends. So I think the third condition should be met without too much difficulty. And with that, I will leave it to Johan to dispute everything I said.